Empowers authorized officers to search premises and individuals if they have reasonable grounds to believe that evidence related to an investigation is present. This allows for the collection of crucial evidence that can support human rights investigations and potential legal proceedings. Judicial oversight. The provision requires the authorized officer to obtain a warrant from a court before exercising these powers. This judicial oversight ensures that the officer's actions are subject to review and scrutiny, providing a check on potential abuse of power. Accountability measures. The provision includes requirements for authorized officers, such as issuing receipts for seized items and returning them promptly after their purpose is served. These measures promote accountability and protect the rights of individuals whose premises are searched. We have further highlighted Section 28 of the proposed bill, and we have indicated that Section 28 is a positive one, as it provides protection to the Commission against indiscriminate execution, attachment, or any legal process in the event of a judgment or court order against a Commission. This provision will also strengthen the Commission's move to be a body corporate. We have further highlighted Section 30, and we have indicated that this provision suggests that it is feasible to appeal against a recommendation to the courts. It is important, however, to note that in our legal system, it is not feasible to appeal against a recommendation. Generally, recommendations are not typically subject to direct appeal, as they are non-binding and serve as advice or guidance rather than legally enforceable decisions. However, in cases where the Commission's recommendation carries legal consequences or has the potential to affect the rights or interests of individuals, it may be more appropriate for the affected party to challenge the decision or take legal action once a recommendation has been implemented or converted into an enforceable decision by a competent authority. In the circumstances, it would be proper for the provision to restrict appeals to decisions that have been made by the Commission. In conclusion, we state that it is important to strike a balance between protecting human rights and freedoms and ensuring that the powers granted to authorized officers are not abused. Establishing clear guidelines, robust oversight mechanisms, and accountability measures can help mitigate the cons and safeguards against potential misuse of power. While the repeal and replacement of the 1996 Act is welcome, the provisions relating to immunity against execution and the creation of the Commission as a body corporate, though very progressive, may need to be critically assessed to determine their propriety and justification in our jurisdiction. In a nutshell, the proposed legislation is generally progressive, and it is supported.
Thank you. Honorable members, we may seek clarifications. Yes, Chair.
Thank you very much for the robust presentation from the judiciary. I have noticed a trend of immunity to the officers, immunity against execution, immunity against... So where are you putting the ordinary people? You want them to be answerable to the law. Then when it comes to institutions and the officers, near everyone now, you go to parliament, parliamentary immunity. You go to judiciary, judicial immunity. You go to diplomats, diplomatic immunity. Leaving only the poorest of the poor to answer to the law for things either done rightly or wrongfully. As judiciary, do you think this is fair? That we should confer immunity on the officers of the officers that work under the Human Rights Commission, and also immunity to the institution itself? What are we saying? Are we saying they are above the law? Are we bringing a precedence that certain institutions or individuals should be above the law? I thank you, the judiciary.
I think, Chair, thank you so much for that question. The catch, I think, in this particular provision is the requirement that one should act in good faith. If an officer acts outside the provisions of the law or does something that is against one's ethical conduct, I believe they can still be prosecuted. They can be sued. So in my view, the catch is on the word done in good faith. The immunity that is clothed rather upon members of the commission or members of staff of the commission is not blanket immunity. Thank you.
Honorable Fove and then Honorable Kasand.
In the submission, we have read seizure of this, seizure of the items, pouncing on those that are suspected to be abusing human rights. Since I want your fair comment on this one, since this Human Rights Commission is supposed to be the referee, or rather the coordinator or facilitator of a relationship between the duty bearer and the right order. I don't know what kind of rights do you think that this amendment is targeting? Is it political and civil rights, or maybe it goes beyond the political and civil rights? Because if there are seizure of items and many other factors, it means that it is inviting other rights that may not necessarily be in the Bill of Rights. What is your view on that particular, especially the test that it has taken? Seizure, pouncing on people without prior notice and so forth. So what is the intention really of this amendment, especially that the commission is supposed to facilitate the relationship of the duty bearer and the right order? I see a bit of confusion. Maybe you can write on that one.
Oh, sorry. Thank you, Chair. It's a rider on Honorable Chair's question in terms of immunity. The response is that in good faith. I haven't seen a definition of good faith in this bill, and I don't know who would determine that this officer is acting in good faith. I just wanted more elaboration because there is no definition what good faith means, and I don't know. There is no organ within the Act which should determine that the officer is acting in good faith. I submit, Chair.
Oh, thank you so much. I just want to look at the term authorized officer. Who can break in and who is this authorized officer? Because we're trying to run away from clashes where someone will say, no, the Act provides that I can. I thank you.
Maybe before they can answer, Chair, the issue is also a careful perusal of this amendment also appeared to be suggesting that the Human Rights Commission is going to be an organization, an investigative agency, and is also going to be a prosecuting agency. So, which is quite absurd, because you recall the problems we had with the Zambia police, why we created the National Prosecution Authority. We didn't want a situation where the police are the investigators, they are the complainants, they are the investigators, they are the prosecutors. How do you look at the ramification of such a drastic change, where the Human Rights Commission wants to be able to investigate, be able to prosecute, first identify the violation themselves to say that's a human rights violation, where they become like the complainant, investigate, and prosecute. When they lose, you say they are immune from execution of their property. You can't execute on their property. You cannot. So what really are we trying to do in a democracy like ours? And in the modern era, litigation costs money. It costs money. You seize my property, you break in my house, you correct, you have investigated, you prosecuted, you've lost the case, I come for you for my costs and everything, then you say you are immune, you can't execute on my property. Are we trying to do justice here? You are the judiciary. Would that be just? Thank you.
In answering the question relating to what amounts to good faith, I'll simply state that I think anything that is done within the precincts of the law, anything that can be said to be reasonable in the eyes of right-thinking members of society, as long as it is done within the precincts of the law, that, in my view, should be said to be in good faith. Anything that can be said to be blatant abuse of authority, that then cannot be said to be in good faith. I'll ask my colleagues to answer the other questions.
Maybe just to add on the question of immunity, like was explained earlier, this immunity is not a blanket immunity. It's for actions that are done in furtherance of what the Act allows the Commission to do. So it's not a blanket immunity. And then if somebody goes beyond those precincts, they're able to be prosecuted or tried for those offenses, if any. And then with regard, there was a question on, I think, Section 17, where authorized officers are allowed to enter premises. And you will note that this provision is actually quite common in other pieces of legislation. One that comes to mind is the Public Security Act, where authorized officers are allowed to enter premises and do what the Act allows them to do. You will note that there's a definition of authorized officer under the Act. I think it makes reference to specific officers that are allowed to enter those premises. With regard to the same Section 17, you will notice that the authorized officer must have reasonable grounds to believe that there's an offense being committed in there. I think that's the catch. And the issue of reasonable grounds to believe that there's either a human rights violation or an offense being committed, this has been subject of interpretation by the courts. So there's several cases that interpret provisions such as Section 17. Thank you.
I don't think that my question has been attended to.
The one relating to good faith.
I asked a question that if you look at this, since human rights is more like a facilitator of the relationship between the duty bearer and the right holder. And what rights do you feel, since this, the amendments are talking about seizures and all that, what rights do you feel that were intended to be tackled in these amendments? Especially that currently we just have social and civil and political rights, because there are seizures of items in here and so forth, and even the searches that are supposed to happen. I wanted to know mainly what rights do you feel were targeted on by the amendments?
I think even mine, I think I've got a complaint. It hasn't been, my question hasn't been tackled.
Okay, maybe let them address one question at a time.
Yes.
Okay, in terms of what rights, I would simply state that it's human rights that are being spoken about. So if there's any imminent violation of a particular right, because the authority, the commission is clothed with jurisdiction, I think, to investigate, and not only to investigate, but to protect human rights. So any imminent violation of any human right can be subject of adjudication by the commission, subject of investigation by the commission, subject of protection by the commission.
Problem here. Why I asked that question is that currently, under the Bill of Rights, you know that we made an attempt at expansion of the Bill of Rights in 2016 with that failed referendum. And I think if you look at the spirit and the letter of the submission, as well as the amendments, what I wanted to know is whether these amendments are going to be futuristic to accommodate the other rights. Should we, broaden the scope of the Bill of Rights? Maybe that I've put it clear.
Maybe just to add on to what has been said, the Act itself defines what those rights would be. And if I can read from the bill, it reads, human rights means the rights, liberties, and freedoms conferred on or guaranteed to a person by the Constitution or any other written law in the Republic. So I think those are the rights that the bill has in mind.
My question has also not been answered. We had lessons from the police. The Zambia police was both an investigative agency and also a prosecuting agency. The best practices have shown that if the police are going to be the investigators, then there must be an independent agency to prosecute. Hence, the creation of the National Prosecution Authority and the devolution of the duties of the Zambia police on prosecution to the National Prosecution Authority. Now, from this amendment, it would appear that there is an attempt to confer upon the Human Rights Commission with powers of investigation and prosecution. So I'm looking at a situation where the agency called Human Rights Commission is the complainant. They identify a violation to say we feel this is a violation. They investigate and they prosecute. If they lose the case at court, you say the officers are immune and you cannot execute on their property. So what are we trying to do in the process of justice? What would you have done? You come and break in my house as Human Rights Commission, get my things, take me through the process, investigate fraud investigations which don't succeed at court. Then I have cause or a claim. The institution is immune. What are we saying? You are the custodians of our constitutional rights as a judiciary. What are we trying to do here? That's a clarification I seek from you. Thank you.
If you go to section 30, I think, of the proposed bill, it clearly indicates that any person that is aggrieved with a decision that is made by the commission may appeal against that decision to the High Court. This, in my view, clearly shows that there is an oversight institution bestowed with authority, of course, to oversee the decisions that are made by the commission, any breaches in terms of the law, if at all there are any. When one makes a particular decision, those can obviously be reviewed by way of appeal at the High Court. So,
Honorable, let's be on the same page. I go to the High Court. The High Court says, Human Rights Commission, you are wrong. Then the officers are immune the institution is immune, I can't get anything from them, is this going to be justice? Even if you pronounce yourselves at high court, whichever court, the institution is immune. Is that going to be justice? That's the issue which is here.
Maybe just to add, the immunity, like I had indicated earlier, is not so much on if the commission, for example, is found wanting. I doubt it to be a scenario where you further find that even if the commission is wanting, the officers are immune. I don't think they're immune from prosecution, because if then the court decides that they went against what powers they are bestowed by the Act, they would not be immune from any prosecution. Then with regard to the question of the commission being prosecutors, well, not that I'm speaking for the commission, but I think maybe what they had in mind, and from my reading, there are issues of public interest actions that I've noticed other similar commissions in other jurisdictions do have, and they carry them on their own. Currently, if I'm not mistaken, any public interest prosecutions or actions would have to be taken by the commission through either the Attorney General or us. And I think what the commission maybe is trying to do is to try and see if they can carry on board certain actions such as those public interest ones.
It's becoming a bit difficult because I'm listening to the words you're using. You're saying, I think. It's not giving us confidence, especially coming from the judiciary.
Let me also stress the fact that the immunity that is granted by this proposed bill is not blanket immunity. If one goes beyond and abuses his or her authority, they can still be sued. They can still be brought to court. So the immunity that is granted is not blanket immunity. Any abuse of the law can still warrant one to get sued by an individual whose rights have been violated.
Okay, sorry. Let's Honorable Kasandwe ask, and then you can come in.
Thank you, Chair. Just on the same question, this is the Human Rights Commission we are talking about, an institution that should ensure that human rights are protected and they are enhanced. And this is an institution we want to give all these powers, even with the possibilities of infringing on people's rights. For example, Clause 17, entering premises without prior notice. Okay? This provision for me is a recipe for anarchy and the abuse. If it is human rights we are talking about, why can't we just put a law that allows the human rights to inform the individual, the premises they want to investigate? Because we are talking about rights here. Okay? Of course, it has even said about the court warrant, but there is prior to that, there is without notice. This is an institution all of us we should run to when our rights are violated. And giving them such powers as suggested in this bill, we are making a human rights a monster, in my opinion. So, what is so difficult? Simply to, for example, remove this part where human rights will just come to my premises without notice. Why can't they notify me? Because one, they should protect the human rights of the rights of the person who has complained. Two, they should also endeavor to protect the rights of the person they are pursuing, so that they strike a balance. Like Honorable Fube said, this institution is supposed to be a referee, where a breach is imminent. Then they give the direction. But the powers that are being given to them, for me, I think it's a recipe for anarchy and the abuse. Even maybe exploring more on what Chair was saying. What has really necessitated these powers to be conferred on the human rights? If it is the police, I wouldn't mind. If it is another institution, probably I wouldn't mind. But the human rights, the custodian of rights themselves, should be given an opportunity to break the law. And then you continue to say, no, if they act in good faith and so on and so forth. I may receive genuine information from a complainant without realizing that it is just meant to malign me. Okay? And the court would even determine, okay, from what you have said, you had good intention, but you are wrong. So how do you balance the equation? That's my concern, Chair.
Okay, you may respond to Honorable Cassandre, and then we'll, Honorable Chinkoli, and Honorable Miyutu, and finally Honorable Hamwat, in that order.
Thank you, Chair. I think as the Honorable Member has stated, yes, on face value, it might appear as though we're actually creating a monster out of the very institution that is supposed to be the defender of human rights. When you look at the manner in which Section 17 has been couched. But I think that the answer to the question lies within that very provision. It says an authorized officer may, of course the issue is without prior notice, but it says for purposes of protecting human rights and freedoms. So this is an officer who is acting for the purpose of protecting the human rights of an individual that are either at risk of being violated by another or are actually being violated by another. So it is really, I think, a balancing act. It's not absolute, but there has to be a justification for it. It must be for the purpose of protecting human rights. And then, when you go to subsection 3, it says this very authorized officer exercising powers under this section shall, before entering and searching any premises, ensure that the occupier or person in control of the premises is present. So it is not really an absolute, it's not a blank check to violate the rights of an individual, but it must be in the defense of the human rights of another, because where my rights end, another person's rights begin. The balance lies in that very now cliche, acting in good faith. So it is not an absolute, that power is not absolute. One must be acting in good faith. I'm not sure, I don't know whether there has been a judicial interpretation of that, but maybe it would be an opportunity also for us to see how exactly that phrase would be interpreted. But I think that it is a standard provision when you look at all legislation that grants power to an authorized officer to act in good faith. I have not seen any interpretation of that one, any definition of that phrase, but that is what I think about it. So it's not absolute.
I think further to what he has indicated, I think the clause relating to without notice is meant to ensure that evidence is preserved. If you just outrightly go to a person's house, indicate to them that you desire to search, you give them the grounds upon which you will conduct the search. Possibilities are that, and you even give them a date when you will conduct a search. Possibilities are that they will hide the evidence that one may be looking for. In any event, I think the court also has a say on whether a search warrant would be granted or not, because one would be required to probably file an affidavit detailing facts upon which one may desire to go and conduct a search. So the court would definitely have a say on whether to grant a warrant or not. They will assess the facts that are presented before them and determine whether it is right to grant a warrant to go and conduct a search or not. Thank you.
Honorable Chinkoli.
Thank you, Chair. Like I said, I want probably to be practical in this manner. When we talk about an authorized officer. Who is this person? Say, for instance, here I am in the commission and conferred with that title of authorizing officer. Do I just stand up here and come to your home, break in, then do whatever I'm supposed to do, then I claim I'm an authorized officer? So I just don't know, who is this authorized officer? I submit.
Thank you, Chair. The bill itself, under I think 16, defines who an authorized officer is. They say the Commission shall appoint suitably qualified persons as authorized officers to ensure compliance with human rights and freedoms. If you go back to the definition section of the bill, it makes reference to this provision as defining who those authorized officers are. But then I get your concern that we have not identified or itemized these particular authorized officers.
Chair, maybe I'll just amplify one or two issues from with this. I worked in some of these institutions where I've been conferred with, such a title, right? Okay. Now, this title does not work in isolation. This title works with the people who are mandated to provide security of a country. Wherever I would go, I'll have this person who is mandated to provide security to both that one who is an offender and the one who is not trying to remedy that. So, if we can define some of these terminologies for fear of them being abused, like my colleague on to put it. Here's someone who, they organize crimes, of which you agree with me that even those in government could be part of that. So we find some of these terminologies may be used to, abuse, the rights of others. So I would want to see a situation where this authorized officer should actually carry the mandate of protecting or providing security to the state. Not just an individual, he's an authorized officer. Hence, most of these, I think you agree with me, are not even applicable. We rarely hear that, no, they have searched this home, they have done what. They are not used. Why? Because of lack of some, if I may borrow his term, Honorable Member for Chiruvi, where he says we need some meat other than just the bone. We need some flesh to help these people carry their duties. I submit, Chair.
You may react to that.
I would agree with you, Honorable Member for Kanyama. Yeah. I think there is need. I do agree with you that there is need to probably outline the qualifications that these authorized officers should have. There is need also to probably identify who these authorized officers should be. Yeah.
Okay. We're remaining with two more clarifications, but let's be very brief because we have to go into the next bill. Honorable Miyutu and then Honorable Hamad.
Thank you, Honorable Chairperson. I think my question is very brief. I just wanted to really find out about this immunity. Is it immunity over the institution or immunity to the human beings? Meaning commissioners and the officers. or is it the entire institution? Where is the immunity? Thank you.
I think section 15 is quite clear. It indicates that an action or other proceedings shall not lie or be instituted against a member of the commission, a member of a committee of the commission, or member of staff of the commission. So immunity is in relation to members of staff and yeah.
But Honorable Chair, I don't know whether they commented on the question which Honorable Chairperson for this committee, the substantive, when he was talking of those tasks of prosecution, investigation in the same institution. I don't know whether you got it clearly. That the commission is mandated to investigate, the commission is mandated to prosecute. Will that commission be able to do those things effectively?
The commission ends at making a decision, and like we have indicated, whatever decision is made by the commission is subject to appeal to the High Court. So we still believe that there cannot be any abuse of the authority that will be conferred on the commission. The commission will still be subject to, whatever decision is made by the commission will still be subject to review by the High Court. There is an oversight institution looking at the activities, the actions that are taken by the commission, decisions that are made by the commission. So there cannot be blatant abuse of authority by the commission. Thank you.
Honorable Hamanta.
Chair, I think we proceed. My point of clarification have been cleared.
Honorable Chisang, you can also introduce yourself and then go into your...
Grateful Chair, again to just tender an apology for coming in late. I had a very urgent matter to deal with outside Parliament. Chair, I have read through this submission, and it's as eloquent and I think as detailed. I just wanted to ask a question that relates to a practical problem that has been created in the dispensation of justice in the country. I draw the attention of the witnesses to section 29 of the, I think it's page 8, when they discuss section 29. Maybe out of good intentions, it is also suggested that the commission should not be subject to execution when one obtains a judgment against it, and then they leave it to the liberty of the commission to be able to decide when to pay out of its revenues the judgment debt. This provision is premised on the principle of reasonableness on the part of the commission, i.e. that the commission is going to rise to the occasion every time a judgment is rendered against it, and without execution it will meet the judgment creditor's entitlement. The country is currently sitting with a big problem relating to local authorities, because I think some 10 years ago it was suggested to confer this kind of protection to local authorities. But over the years, it came to be established that local authorities came to be lumbered with a lot of judgment debts that they had not met, to the extent that central government was asked to actually sort of help them out. What protection, how rather can we be able to ensure that whoever is going to be responsible for management of the commission will not become, for lack of a better term, a delinquent like local authorities became, and begin to fail to pay judgment debts if you're going to disentitle those who got judgments against it from execution? I hope that question is very clear, Chair. Thank you.
Thank you so much. Section 29, in my view, is mainly meant to ensure that the Commission is not crippled in the event that it's inundated with a lot of judgments against it. This is a commission that does not generate income. This is a commission that is funded probably by central government, and it is also reliant on donor funding, I suppose. So if you look at subsection 2 does make it mandatory that the commission should pay out money. So I believe with subsection 2 of section 29, the commission still remains mandated to pay out any judgment debt.
That's exactly the trouble that I have with the section. We are assuming that commission is going to be managed by angels. Human beings always create problems. The question I'm asking is, how can we secure that whoever is in charge of the commission during the material time is so reasonable that he will strictly comply with the provisions of section 2, because these provisions were introduced in the law that applies to local authorities. And over 10 years we have accumulated so much debt on local authorities simply because they were not committing to paying as they were expected to pay. So what protective position can we take in ensuring that those who are going to be in charge of the commission will not be, like I said, for the lack of a better term, delinquents who don't like paying debts?
Maybe what we may need to do is to add another clause that gives a period within which a debt is supposed to be paid, like is the case with the local authorities. If judgment debt is not paid out within a specific period, then one can levy execution against a particular local authority. So in this case, I would also suggest that maybe a provision that requires that debt should be paid out within a specified period should be noted. And if the debt is not paid out, then one would be at liberty to levy execution. Thank you.
Just to follow up to that one. If this commission is also being funded by donors, is it just for them to now, I think it's taking me back to Honorable Kasandwe's question, where officers can go and maybe destroy property. At the end of the day, there will be no type of retribution to those citizens as they lose that property. Do you think that this subsection is setting up the commission for failure? Because I don't think that they'll be able to meet their obligations.
Subsection?
In subsection 2, where there's a judgment against the commission, and then they're depending on donor funds together with public funds. So assuming that they probably won't have enough funding as is for most of these institutions, but by then maybe they would have already destroyed somebody's property. Is it just for that citizen to have their property maybe destroyed or taken away by an institution that essentially doesn't have money at the end of the day?
I would simply state that the provisions as they are would require officers, in my view, to act in good faith. They would require officers to act within the provisions of the law. So the only other issue, like I have indicated, that may compel the commission to pay out, if at all they are sued and there's a judgment that is rendered against them, the only alternative that we would have maybe is to add the provision that allows the commission to pay out judgment debt within a specified period, after which execution can be levied. But as it stands, I think the provisions of the proposed bill, in my view, are clear. Section 17 would come in, I think, in aiding or ensuring that officers do not act outside the provisions of the law. There's a requirement that one may go to court, and that is if they desire to conduct a search, they may go to court and present facts detailing reasons why they desire to conduct a search upon one's premises. And the court obviously would have, before granting a warrant, would have obviously looked at the facts and determined based on the reasonableness of the facts that are detailed. So I doubt if there will be any abuse at all.
Okay, thank you so much. We can go into the next bill.
In presenting our submissions on the National Prosecution Authority, we have outlined the introduction, and we have stated in our introduction that the proposed amendments deal mainly with the administration of the National Prosecution Authority. The administration of a prosecution authority is of vital importance for several reasons. We have outlined those reasons. We have highlighted on page number 5 section 4.1 of the proposed bill, and we have indicated that this provision is a progressive provision and is important for several reasons. We have noted that the provision addresses the issue of conflicts of interest that may arise when a person participating in a board or committee meeting has a personal interest in a matter under consideration. By requiring the declaration of interest, it aims to ensure transparency and mitigate the risk of biased decision-making. Transparency and accountability. Requiring individuals to declare their interests fosters transparency within the organization. It enables other board or committee members to be aware of potential conflicts and make informed decisions. This provision holds individuals accountable for their personal interests and promotes a culture of integrity and ethical behavior. Preservation of objectivity. The provision restricts the participation of individuals with conflicts of interest from engaging in discussions or voting on matters in which they are personally interested. This safeguard helps maintain the objectivity and impartiality of the decision-making process, preventing undue influence and ensuring that decisions are made in the best interest of the organization or entity being governed. Protection against legal and reputational risks. Implementing and adhering to this provision reduces the organization's exposure to legal and reputational risks. By addressing conflicts of interests proactively, the provision helps prevent situations where decisions could be challenged on the grounds of bias or self-interest. This can help the organization's reputation and credibility. Ethical and good governance practices. The provision aligns with principles of good governance and ethical conduct. It reflects the importance of fairness, accountability, and responsible decision-making within the board or committee setting. By enforcing these practices, organizations can enhance their overall governance framework and build trust among stakeholders. Overall, the provision plays a crucial role in promoting transparency, accountability, and ethical behavior within the board or committee environment. By effectively managing conflicts of interest, it helps ensure that decisions are made in the best interest of the organization and its stakeholders, safeguarding its reputation and integrity. We have highlighted Section 6, and we have stated that Section 6 is equally progressive and is significant for the authority for the following reasons. One, protection from legal proceedings. This provision provides legal protection to members of the board, committee members, and staff of the prosecution authority. It states that no action or legal proceedings can be initiated against them for any act or omission done in good faith while exercising their powers, functions, or duties conferred under the relevant act. Encourages independent decision-making. The provision promotes independence in decision-making by safeguarding board members, committee members, and staff from the fear of legal repercussions. It allows them to carry out their responsibilities without the threat of personal liability, thus enabling them to act impartially and in the best interest of justice. Facilitates effective prosecution. By providing protection from legal actions, this provision allows board members, committee members, and staff to focus on their roles and responsibilities in effectively prosecuting cases. It encourages them to make decisions based on the merits of the case rather than being unduly influenced by concerns about personal liability. Fosters confidence and trust. The provision helps build confidence and trust in the prosecution authority. It reassures members that they can carry out their duties without fear of legal consequences as long as they act in good faith. This protection enhances the independence and integrity of the authority, contributing to public trust in its operations and decisions. Supports innovation and risk-taking by shielding board members, committee members, and staff from legal actions. The provision encourages innovation and risk-taking. It allows them to explore new approaches, strategies, and initiatives without a constant fear of being held personally liable if the outcomes are not as desired. This freedom to experiment can lead to improved process and outcomes in the prosecution of cases. Attracts competent professionals. The provision helps attract competent professionals to serve on the board, committees, and staff of the prosecution authority, knowing that they will be protected from legal actions when acting in good faith. Individuals with relevant expertise and experience may be more willing to take up roles within the authority. This can contribute to the overall effectiveness and competence of the prosecution. In summary, this provision is crucial for the authority as it provides legal protection to its members, ensuring they can fulfill their duties without fear of personal liability. By promoting independent decision-making, fostering trust, facilitating effective prosecution, and attracting competent professionals, the provision contributes to the authority's ability to carry out its mandate in a fair and efficient manner. The proposed amendments, in conclusion, are generally progressive and are supported by the judiciary insofar as they address proper and efficient administration of the National Prosecution Authority. I thank you.
Honorable Fube.
I have two concerns on this bill. One is to do with the secretary of the board. I don't know how that stands, the decision of the secretary of the board, because in the Principal Act, the secretary's role has been defined clearly, and then the removal of the word secretary leaves the proposed amendments so open and naked without secretary of the board. Another concern I have is if you look at the Principal Act in Section 7, the DPP was a chair, and now the chair is proposed to be somebody who just qualifies to be judge, and Section 7 to me should be read together with Section 8, which stipulates the roles of a DPP, and also consider Article 180 of the Constitution. I don't know how it stands with you that the chair is no longer going to be the DPP, and the DPP will only be an ex-official, but Section 8 is not amended, is not one of the amendments that are coming forth in this. I don't know how you look at such an amendment, especially in line with Article 180 of the Constitution. That's my submission.
I think that best practice is that the CEO of an institution such as NPA would not have at the same time to be the the chairperson of the board. I think if you look at what is prevailing generally, and I think it's for purposes of checks and balances, accountability, and also removal of arbitrariness, it sits awkwardly, I think, that the DPP should both be head of the prosecution authority and at the same time head of the board. Imagine the Director General of ACC being at the same time chairperson of the board. I think at the moment you have a situation where the board chairperson is different from the Director General. And I think even in this particular bill we have just been looking at, the Commission appoints the Director General, but the Director General only sits on the Commission as an ex officio. So I think that is best practice for reasons that I have already stated.
It's best practice, but it leaves at Section 8, not amended. And if you read properly in the powers that the DPP have, in Article 180 of the Constitution, what I'm trying to say is, yes, the amendment would sit in the best practice, but if you leave what is in Section 8 and the Constitution untouched, where does it leave this amendment?
Because it's one.
But they end up forgetting questions because of the same.
It's almost the same.
We've been down this road before. Let them respond, and then you come in.
Section 8. Would we be aided with the Act so that we look at the provisions of Section 8? Section 8. Yes. Okay. What? Yeah, all the views would have been taken in that. Yes. The members want to ask. And the Constitution. I think, Councillor, you look at Article 180 of the Constitution and Section 8 of the NPA Act, I think indicates that these two provisions are talking about a prosecutorial authority of the DPP. The issues relating to conduct of prosecutions, issues relating to issuance of fiat. It does not talk about issues relating to policy. I think yes. Those, I think, if you look at the Act is clear. It
You read 183. Okay. I don't know what you call it in those.
Article 180.
Article 183.
180, sabbatical 3.
Sub what? 3. You read it. Sub 3.
180 sabbatical 3. Okay. So Article 180, okay. Article 180, Sub-Article 3 states that the Director of Public Prosecutions is the Chief Prosecutor for the government and head of the National Prosecutions Authority. The Director of Public Prosecutions may institute and undertake criminal proceedings against a person before a court other than a court-martial, for an alleged offense to have been committed by that person.
Okay, so may I have a question, Honorable Chair? When you say, what you have read says head, H-E-A-D, what is it to be a head?
You are in charge of a particular
So I'll give you an
institution.
example. Here is a cabinet meeting, and the president becomes an ex-official in that, doesn't chair that meeting. Is right? Is the head who is is the head of that cabinet. But when the cabinet is meeting, he's not chairing. That's right? According to the Zambian context, it's right?
Okay, he is head, and the powers are clearly outlined. Yes.
Is meeting, and is the head, but is not chairing. It's right. So, Honorable Chair, for me, I just want to express myself from a layman's point of view. You are just causing confusion for us deliberately. Just deliberately. I don't know why you want to cause confusion. You are going to cause confusion in that institution. If you are not going to amend your constitution, you are going to cause confusion there. We are going to sit here again to redress this. Because you will find that the head of the prosecution will be differently operating from your board. This is what we are causing here deliberately. Things which are very clear. Some of us, we haven't gone to the university, but naturally we are born like that. These are certain things we are, you know what we are doing? We are throwing stones. We are running towards a point, but before we reach that point, we are throwing stones there. Then we are reaching the point, we find those stones. Again, we shall need a grader to remove those stones from the road. This is what we are doing here. First, you amend that 3. Amend, then you bring this. Then it will work. Otherwise, when you apply logic, it won't apply. When you apply morality, it won't apply. So now, if we are moving morality, we are moving logic, what values are you going to use now here? What type of an institution do you want to create? Because logic, you have removed it. Morality, you have removed it. Give me the values that you are going to use to make sure that the authority now becomes genuine and unique. Give me. Because you have removed these 2. You don't want morality, you don't want logic. Thank you, Honorable Chair.
Sorry, let me just come in before they respond. I think let's not debate. Let's ask the questions, and the witnesses are not the originators of the bills. Let's keep that in mind. That it's coming from the ministry. They're simply here to assist us. So, Honorable Kasando, you may come in. Thank you.
Thank you, Chair. I just want to ask a question in relation to the example that has been given of ACC, that they have a board and then a director. I would have loved if the witness gave an example of the Bank of Zambia governor and also the Chief Justice, where they are coming from. There is no any other person beyond the Chief Justice. Is everything. There is no any other person beyond the Bank of Zambia. The governor is everything. These are the same institution like National Prosecution Authority, where the drafters of the law, the spirit, they wanted to ensure that there is no interference whatsoever on the operation of the DPP. Before I ask a question, Chair, I take you to the bill on page 5, number 4, clause 3. I think is yes, number 7, clause 3, where it says, the board may, by direction in writing, and on conditions that the board considers necessary, delegate to the Director of Public Prosecution of any board's functions under this act. Pure interference.
It is an administrative law.
I submit, Chair.
Okay, I think let them react to it, and then Honorable Chitanga can come in.
Chair, the issue that Honorable Gasanda has raised, if I'm going to ask a question after the answer, I'll be repeating it.
Okay, so just as long as we don't debate the point.
Chair, just to, first I wanted to just clarify the context in which Honorable Kasandwe raised the issue. Today, there's a distinction between the judiciary and Bank of Zambia. Bank of Zambia, the governor actually chairs the board. Judicial Service Commission, I think from 2016, when we came to Parliament, that's when they decided to change the law and remove the Chief Justice as head of the Judicial Service Commission and gave the powers to the President to appoint a nominee who then chairs JSC. Now, it is important to observe what Honorable Gasandwe said, because if the witnesses will speak objectively, that is the current cause of chaos in the judiciary. The fact that the Chief Justice does not chair or does not lead JSC is what has caused the current problems in the judiciary. Now, from what Honorable Miyutu said, we always need to keep constantly in mind that there is a purpose why, under the Constitution, the DPP does not report to anybody, is not accountable to anybody. It is to enhance the independence of the prosecutorial powers that is got. So from the lessons that we have learned in the judiciary, I think this committee will benefit from your wisdom, because you're sitting with that experience of the chaos that we are seeing as bystanders in the judiciary, vis-a-vis a comparison with the DG at Bank of Zambia. We want to speak, I need to speak from a perspective of good corporate governance, but it's important also to establish what is important. Is good corporate governance more important than independence of the DPP? I just thought I should put that in perspective, Chair, as I answer the question. Thank you.
If you look at Section 4 of the proposed bill, I think the functions of the board are elaborately stated. There are not so many functions. And if you look at these functions do not in any way, in my view, amount to usurping the authority or the powers of the DPP. The three functions that have been outlined relate to governance of management of the NPA. They relate to approval of the annual work plan of the NPA, the approval of the budget estimates, and promoting effective corporate governance of the NPA. I think the DPP still remains the one in charge of the National Prosecution Authority and will not in any way be subject to the authority of the board. Subsection 3 clearly outlines that a board may, by direction in writing and on conditions that the board considers necessary, delegate to the Director of Public Prosecutions any of the board's functions under this Act. So this clearly shows that the board may delegate the authority, the functions that are outlined under Section 4 to the Director of Public Prosecutions. But in terms of prosecutorial authority, the DPP will not be subject to the board. The DPP still remains the head of, will still remain the head of the National Prosecutions Authority.
Honorable Fove, and then Honorable Miyutu.
Chair, if I may just ask that maybe we read Article, it's just that I'm not with the Constitution, Article 180 about controls. No one should control, not institution, no individual. Can somebody read that for me? Yes, the particular article that talks about control and no individual, no institution should
read
control.
Article 187.
Yes.
The Director of Public Prosecutions shall not be subject to the direction or control of a person or an authority in the performance of the functions of that office, except that the Director of Public Prosecution shall have regard to the public interests, administration of justice, the integrity of the judicial system, and the need to prevent and avoid abuse of the legal process.
Okay, if I'm a manager, I prepare documents for administration. And those documents, I have no say about them until they are approved by some authority or some institution. That's when I will implement, because this one talks about programs, policies, and strategies of the authority. Strategies of the authority may even mean that nitty-gritties of how we are supposed to implement prosecution strategies. And if those strategies have been prepared, before we implement as a management, they are supposed to be subject to approval. Is that not control? If those, before they are implemented, the programs, if for instance we are trying to expand the what from beyond the 10 provinces, we want to expand to districts so that we have a trickle-down effect at the district. I have to wait for the board to approve that, and I'm an ex-official who is not even a chairperson, but I'm the head of that particular institution. Is that not control? Does that not interpret into control? Because I can't do anything until those things are approved. The strategies are approved. We will prepare management documents, we will prepare the budgets and the like, but I cannot effect anything. Just like the budget cannot be spent when one of our roles as MPs in Article 60, I think 61 or 62, is that we should approve the budget. The president and the executive cannot start spending until we approve the budget. So that is the scenario that we are in, that this NPA cannot start doing anything, and the Director of Prosecution cannot do anything until the board approves, of which the chairperson is no longer there. DPP is somebody else, and the DPP is just an appendage, an ex-official is an appendage. That's how I understand these things. So I don't know what the judiciary can say about that.
There should be a distinction between the National Prosecution Authority and the Office of the DPP. Article 180 is talking about the functions of the Office of the DPP.
Yes.
The National Prosecutions Section 4 is talking about the National Prosecutions Authority. Section 4 does not say that the Director of Public Prosecutions shall be subject to the board. There's a distinction.
Which one presides over the NPP?
Article 180 talks about the Office of the Director of Public Prosecutions.
Yes.
Yes. Section 4 talks about the functions of the board in superintending
the NPP.
Over the
NPA.
The National Prosecutions Authority,
yes,
in relation to its management, the management of its affairs. So the Office of the Director of Prosecutions is not being interfered with. His authority is still intact. He's not subject to.
That's serious crisis, really.
It's not. It's not. Yeah.
Let them finish talking, and then one member at a time, please.
No. 4.3. I don't know what you call these things. Subsection 3. The board may. So our underline also the word may. By direction in writing and on conditions that the board considers necessary, delegate to the Director of Public Prosecutions. So what are you saying? You see that?
What I'm trying to say is that there's a distinction between the Office of the DPP. The functions of the Office of the DPP, his powers are clearly outlined in Article 180. And this power is not supposed to be interfered with. The execution of this power that is noted under Article 180 is not supposed to be interfered with. If you go to Section 4, Section 4 merely brings in the functions of the board, and it indicates that the functions that are vested in the board may be delegated to the Director of Public Prosecutions. This does not in any way take away the authority, prosecutorial authority that the Director of Public Prosecutions has. So,
please let's give an opportunity to Honorable Chsang.
Chair, I'm grateful for the opportunity. I'm having difficulties, like my colleagues are, in how the judiciary would like to help us traverse this complex, not so complex situation. The Constitution casts the DPP in his individual capacity as head of the National Prosecutions Authority. In the Constitution, it puts him in that position. And his constitutional functions cannot be divorced from the National Prosecutions Authority, because even the National Prosecutions Authority is set up by the Constitution. I had tried to guide, and I like the fact that you want to see this from a perspective of corporate governance. I'm a certified corporate governance practitioner myself, and I understand exactly that perspective. But even in corporate governance, Chair, we have exceptions on how we cast the responsibility of management and the board. There are exceptions when you talk about privately owned companies or family companies, where you actually find that the managing director is also the chairperson of the board. It is recognized in corporate governance. The idea is to ensure that the philosophy of the institution that you are dealing with complies with the ethos of board practice. You also have a similar scenario which we related to, of the Bank of Zambia, specifically because the Bank of Zambia is a regulator of the financial services. It was found prudent to allow the sitting governor of the Bank of Zambia to also chair the board. And by extension, I've worked at Comesa Bank myself, and I've also consulted with African Development Bank. We find that the governor or the president of the African Development Bank and the president of the Comesa Bank also chairs the board. The reason is simply because this is the superior institution that regulates the financial services sector. Prosecutions, as we have established in the country, is the preserve of the Director of Public Prosecutions. In fact, historically, we never even had NPA, if you remember. We had the DPP as an individual in the Constitution and in the CPC. Even when we set up the NPA, the Constitution cast him as the head of the institution. So with those kinds of, deliverables, don't you think there would be wisdom to allow the DPP to maintain his independence by letting him be the head of even the board, if the board is considered necessary? And I ask this question and relate you back to what we experienced in 2016. All the way up to 2016, the Chief Justice was the head of the Judicial Service Commission, because judicial services are a specialized service to the nation. But for reasons that, for lack of a better term, I would term political, it was felt necessary to divest the Chief Justice of the power to lead the judiciary and vest that in the presidency, who then nominates a suitable person to head the Judicial Service Commission. I'm a legal practitioner of 31 years. I know that that has compromised the judiciary in the country. Are we about to create a similar problem if we also want to divest the DPP of his constitutional powers by making him subject to a board that he can't have control over? That's the philosophy from which I'm trying to ask this question. So I don't know how you can traverse it, or if you're still going to insist that we should allow the DPP to be under some sort of board. Aren't we going to dilute the power that we gave the DPP in the Constitution? That's my question, Chair. I know it's a long question, but that's how I wanted to cast it. Thank you.
I would still stand by my earlier position, but I would also want to indicate that what you have asserted is correct. When you have a situation where an institution has got an administrative head, and above that administrative head, there's a board that also performs certain functions relating to that institution, like is the case with the NPA approval of budgets and all. There are chances, obviously, that there would be interference in the operations of the authority. But in terms of the prosecutorial authority, I do not see how that would be in any way interfered with, because the functions of the board are clearly outlined, and the functions of the office of the DPP are also clearly stated. But if we have that situation, there are possibilities that obviously the office of the DPP could be interfered with, but not in relation to the prosecutorial authority that the DPP has, because those are clearly outlined by the Constitution. The functions of the board are also clearly outlined by the Act itself. Thank you.
Okay, Honorable Yutu and then Honorable Fore.
Thank you. The new clause at section 4, the Principal Act is amended by the insertion of the following new section immediately after section 7. 1. Functions of the board. Subject to the other provisions of this act, the board shall provide strategic policy direction to the authority. Hey, strategic. Maybe you can guide what is the implication of strategic policy direction to the authority. Maybe you can help us.
I think I'm still having problems. And I think my problems are straightforward. For instance, I may not be a legal brain. I know the status of the actual member and an official, ex-official member. They are of different status. And I think unless we have been exposed to different knowledge. And then when we look at that, when we talk about control and interference, you cannot separate the approval of things that facilitates even the same prosecutorial authority you are talking about. For instance, in the judiciary, there are delays in terms of how cases are done and all that. Some of these delays could be a reason of both softy as well as hard policies. What I mean by this is that some of them could be has to do with the infrastructure, and some of them have to do with paper, issues that we can talk about. And the argument that the suggestions or the amendments do not interfere with prosecutorial authority in the Constitution, I find that a bit strange, because I gave an example earlier that if, for instance, I have met with my management team, I have prepared everything, but I cannot do anything until what we have prepared as a blessing of a different authority. It means that there is already control. It means that that particular institution that approves has more supreme, has supreme powers than where the management is seated. Anything that approves has supreme powers. So I am having problems when you say it does not interfere with the prosecutorial or
Yes, please.
I will still maintain my position. Article 108 is very clear. Institution of proceedings, in my view, has got nothing to do with strategic plan of the institution. The DPP has got power to institute and undertake criminal proceedings. So how then does the issue of strategic plan interfere with his authority to undertake or institute criminal proceedings. The authority that is mentioned under Article 180 is very clear. It's in relation to the prosecutorial functions, the legal functions of that particular office. And Section 4 merely outlines the managerial operations functions of the National Prosecutions Authority. So I do not see how approval of a strategic plan would adversely interfere with the DPP instituting criminal proceedings in a particular matter.
I have another question.
Okay. Unless the questions are about something else, if it's about the board, I think we've spent more than enough time on it, and it's been exhausted.
Honorable Chair, I have one question.
All these questions about the board? Okay. Honorable Chinkoli? It's different? Right. Okay, so, well, they've taken a position. I think on that one we have to move on,
Yes,
unless it's about something else.
Chair, my question is very simple. It's very simple.
And please, let's be very brief.
Yes, I believe that judiciary is exposed in the legal world. Maybe you can help me. Give me an example of a country which is operating the way you want Zambia to be. Thank you.
It's about the same? Okay.
For me, Chair, I just want to find out, especially that the judiciary, you have that exposure and understand probably the challenges that we have been going through. Could you share with us the rationale, or what are the benefits you think, probably the challenges that we have had, that could lead to us having this board? What could be the benefits, or what could have been the challenges, in your view? Of course, I know you are not the architect or the owner of this bill, but from your professional point of view, why do you think, what could have been the challenges that we are curing now? Because I believe for us to come up with something, there could have been something that we are trying to cure vividly. Thank you.
In terms of the advantages, I think the advantages are clearly outlined. We have clearly outlined in our submissions. The fact that this provision will ensure that there is transparency and accountability, there is preservation of objectivity, conflict of interest management, protection against legal and reputational risks. We have outlined in our submissions the advantages that we feel this will bring about.
Accountability. There has been no transparency, and that's what we are curing. That's what you are telling us, Council.
Well, maybe just a small addition. Earlier, and first of all, I want to appreciate the fact that the members do recognize that the judiciary is not the architect of the document. So we are simply looking at things also from the perspective of the crafters of the provision. But of course, that is not to say that we cannot say anything about any issues that we may see arising out of these provisions. Another issue I think that we earlier alluded to, which may have been at the back of the minds of the crafters of the provision, is simply an aspect of best practice and good corporate governance, which senior counsel has actually ably also discussed. And from, I think, the proceedings that have gone on here, the view that that emerges is that there are quite strong positions that you know, we are taking, and in my view, perhaps this is an opportunity for us to subject the paper, the document, to further scrutiny, because certainly, much as good corporate governance is something that we need to uphold, you have head of the NPA being at the same time head of the board. Yes, in terms of corporate governance, that may have its own repercussions, but maybe we cannot entirely overlook what Mr. Chisanga, Honorable Chisanga, pointed out in terms of what is more important, good corporate governance or the independence of the DPP in terms of exercising its powers as granted by the Constitution. Yeah, maybe it's a chance that we have to further interrogate the document, but otherwise, from where we stand, we did not see anything that was completely, you know, uncharacteristic of rather, maybe to put it this way, anything that would undress the DPP of the powers that are given to him by the Constitution to undertake his work without interference from any authority or any person. So maybe for now we will leave it there and just carry out some more scrutiny of the bill.
Okay. Is it something different, or it's the same issue?
You know, Chair, just if you permit me, I think Secretariat can confirm. The witnesses are at liberty to give us a supplementary written position should they change their mind after doing a literature review. I think because we've taken positions that are completely at par with them. They are on the other side or on the other side, but we want to get a benefit of them assisting us, if they can.
Thank you, Chair. Maybe for future interaction, the expectation of this committee is for witnesses to strictly and seriously interrogate the pros and cons of the proposed bills, because they are the ones who are doing research and so on and so forth. As a committee, we may not have that time to go around and look at best practices and so on and so forth. So our expectation is that is to scrutinize probably clause by clause, where it has worked, where it has not worked, what is the best practice, so that as honorable members of parliament we can appreciate that diverse research. But simply making comments like that, it's very difficult for us to be assisted. We expected them to say, this clause, these are the pros, these are the cons, this is where it is practiced, this is where it has worked, this is where it has failed, so that we have a buffer of knowledge from where we can tap and make a decision. That's what I wanted to submit, Chair.
So anyway, thank you for that. I think it also takes us back to what Honorable Miyuto had asked. He wanted to know which country. I'm not sure if you're ready to respond to that. If not, I think we can go with the guidance given that you can still add on later on.
We did not look at any other country. I think we just looked at what is currently obtaining in Zambia. We must have looked at what is obtaining at the Legal Aid Board. The Legal Aid Board also has the same scenario where the board is headed by another person who's not the director of the Legal Aid Board. We also looked at the Anti-Corruption Commission, and we noted that at the Anti-Corruption Commission, the head of the Anti-Corruption Commission, the head of the board of the Anti-Corruption Commission is not the Director General. We also looked at the judiciary ourselves. Of course, the council had, senior council had intimated there could be one or two issues, I think, that would Yeah, you arise in a situation where you have the head of the institution not being, you have a board which is headed by a person who's not the head of the institution. I think you have, you have issues that may arise.
Okay, with that said, it brings us to the end of our interaction, and thank you so much for coming. We've taken the position, and it was very clear. So thank you for that. We will now withdraw the immunity that was bestowed upon you in the beginning. Thank you so much. Please have a good day.
You already know. I always think about you. Every day I pray for blessings to follow you. Akutimani is beautiful, but it's nothing compared to you. Chikondi changa nchopanda malile kawauze akwani komweko kapakile ndaza mitita mwaiwe kumabe sinengamile iwe ndine oyela pasi sisapachile